Jefferson County Court at Law number 2 is back in session, and cause numbers 330-678, cause number 333-424. Both cases are styled the state of Texas versus Candace Aaliyah Bessert. Prior to the court accepting the plea agreement, in this case, the state as well as the defense asked that the case be placed on hold.
Yes, sir.
So that they can have a conference. Mr. Johnson?
Yes,
What
sir. Your Honor, after speaking with defense counsel,
We can, we can go ahead and apply,
yes, sir. The defendant is we're going to ask for a short reset to let the defendant apply for pre-trial diversion program.
So I think you're withdrawing the offer at this time.
Yes, sir.
And you have any objections?
No, Your Honor, no objection to this.
Okay, so we're gonna at this time, the court is not gonna go forward on the plea agreement. The state is withdrawing its offer. And so the case is going to be reset. Is that correct?
Yes, sir.
To give the defense an opportunity to apply for pretrial diversion.
Yes, sir.
Okay, so let's reset this case till second week of February. All these cases, yes. We're gonna reset it to February 8th.
Yes, sir.
Of 2023. So Mr. Lawrence, you can get your reset. And Ms. Besser, once you get your reset from your attorney, you'll be free to go. You have a blessed day. Okay, you're welcome.
And Your Honor, I thank everyone for being so understanding.
Okay. Okay, you're welcome. Please stand on the X and sign for the reset.
Thank you.
Okay, we have,
What happens to the number? You can sit right there.
No. It's dismissal, but just. I don't know. No. 2 years, 3, 4. Then you're gonna just move on. I need to. Yeah. Thank you.
Jefferson County Court at Law number 2 is back in session. Next case is cause number 331-886, case of South State of Texas versus Barrett Andrew Yoder. Okay.
There you go.
Your Honor, this is Mr. Yoder.
Okay. Mr. Yoder, your full name is Barrett Andrew Yoder.
Yes, sir.
Mr. Yoder, would you please raise your right hand? Mr. Yoder, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Yoder, you may put your hand down. How are you doing, Mr. Yoder?
I'm good, sir. How are you?
I'm doing fine. Thanks for asking. Now, Mr. Yoder, you're here represented by your attorney, Attorney Willard Hall. Attorney Hall, how are you doing?
Great, Your Honor, thank you.
That's good. Mr. Hall, do you waive a record?
Yes, sir, we do.
Mr. Yoder's case. And the state is represented by Attorney Raymond Shearer. Attorney Shearer, how are you doing?
Doing good, Your Honor.
Mr. Yoder, I have before me an information that was filed by the Jefferson County District Attorney's Office. This information alleges that on or about November 28th of 2021, while you were operating a motor vehicle in a public place in Jefferson County, Texas, that you committed the class A misdemeanor offense of driving while intoxicated. A second, and also, Mr. Yoder, this information further alleges that it further presents in the said court that prior to the commission of this offense, that you, Barrett Andrew Yoder, on December 28th of 2016, in the County Court at Law of Chambers County, Texas, in cause number 33092, that you was convicted of the misdemeanor offense of driving while intoxicated, and that offense became final before the commission of this offense. Is that true or not true?
Your Honor, the state is going to abandon that paragraph and allow him to plead to the lesser included of the DWI first.
Okay, so Mr. Yoder, the state is abandoning the enhancement paragraph. What that basically means is they're not going forward on the class A misdemeanor and DWI second. And by them abandoning the enhancement paragraph, you'll be charged with a class B misdemeanor offense of driving while intoxicated first. All right. So, Mr. Yoder, do you understand what you've been charged with? A DWI first.
Yes, Your Honor.
And to discharge, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
Okay, hold on.
I may have put on the plea sheet that it was a class A misdemeanor.
I corrected that.
You did? Oh. Now, Mr. Yoder, I also have before me a document that is titled, yes, DWI first. A document that is titled misdemeanor plea admonishment. Oh, he signed it in the wrong box. It has to be, you're gonna put it right here.
Okay.
That box that says DWI first. Just strike out the B. It's gonna be a none.
Gotcha.
Okay. Now, Mr. Yoder, I also have before me a document that is titled misdemeanor plea admonishment. Do you recognize this document?
Yes, Your Honor.
Now, the box that's checked is driving while intoxicated first offense, class B misdemeanor confined in the range of punishment confinement in jail for at least 72 hours, but not to exceed 180 days, a fine not to exceed $2,000, or both such confinement and fine. It also states that a conviction resulted in community supervision will require a drug and alcohol evaluation, rehabilitation, payment of costs of rehabilitation, completion of an alcohol education course, and interlock if breath alcohol concentration was greater than or equal to 0.15 or more. Do you understand that?
Yes, Your Honor.
Now, on page 2 of this same document, there's a set of initials BY on a line that's next to a box that's checked guilty. Did you place your initials on this document?
Yes, Your Honor.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, Your Honor.
On the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, Your Honor.
And is this your signature on the line that is titled defendant?
Yes, Your Honor.
There are 2 boxes that's checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, Your Honor.
The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, Your Honor.
I also have before me a document that is titled discovery certification. Do you recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled defendant?
Yes, Your Honor.
Mr. Yoder, before you signed and initialed all of these documents, did your attorney, Mr. Hall, go over these documents with you?
Yes, Your Honor.
And did you read and understand everything in these documents?
Yes, Your Honor.
And is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
Mr. Yoder, are you a citizen of the United States?
Yes, Your Honor.
State, I have before me State's Exhibit number 1. State, would you like to offer State's Exhibit number 1 in evidence?
State would, Your Honor.
No objection.
No objection. State's Exhibit number 1 is admitted. Mr. Hall, you've advised and counseled Mr. Yoder. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Yoder, your attorney, Mr. Hall, has advised and counseled you. Are you satisfied with his representation?
Yes, Your Honor.
Has he provided full, effective, and competent legal representation?
Yes, Your Honor.
Mr. Yoder, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers was freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Oh, I gotta change this here. Okay. State, do we have a plea bargain agreement?
Yes, Your Honor, we do.
And what is that agreement?
The agreement is for Mr. Yoder to plead to the lesser included of Class B. In exchange for that, he will do 180 days in the Jefferson County Jail. However, that time will be probated over 2 years, and a $1,500 fine will be assessed, along with 80 hours of community service. He will require to have the drug and alcohol intervention program, and also be required to have an interlock during this time.
Mr. Hall, is that the agreement?
Yes, Your Honor.
Mr. Yoder, the state is offering that you serve 180 days in Jefferson County Jail. However, you would not have to serve 180 days in Jefferson County Jail because you'll be placed on probation for a period of 2 years. During the 2-year probationary period, you'll be required to pay a fine of $1,500 and court costs of $422, which comes to a total of fine and court costs of $1,922. You'll also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You will be required to pay Jefferson County DWI education class and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is, the total amount that you'll be required to pay each month while you're on probation, is $160. Mr. Yoder, will you be able to pay the $160 each month?
Yes, Your Honor.
You'll be required to perform 80 hours of community service, attend and complete a DWI education class, and have a drug assessment. You'll be required to install a DWI interlock device on any vehicle that you own or operate. Also, he's attending and completing the DWI intervention. That's on here too. You'll also be required to attend and complete DWI intervention. And you will also be required to adhere to the other standard terms and conditions of this probation. Mr. What did I say, interlock? You'll also be required to have an interlock device. Now, Mr. Yoder, do you understand the state's offer?
Yes, Your Honor.
Do you think that the state's offer in your case is fair and just?
Yes, Your Honor.
And do you accept the state's offer?
Yes, Your Honor.
Okay. Mr. Yoder, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Yoder, you're going to stand on the X next to your attorney and follow the directions They have to do your paperwork on, South. This is cause number 330-690, cases Tyler, State of Texas versus Alicio Ventura. Alicio Ventura is present in court with his attorney Charles Rojas. Attorney Rojas, Mr. Ventura's case is on the announcement docket. What is your announcement?
Judge, we're gonna ask for another announcement docket. We have an agreement to pay a fine plus restitution. It's gonna come out to about $1,600. Mr. Ventura is asking for about 2 months if we can do that, Judge.
Okay, give us a reset date. That should be 2 months.
That's fine.
Okay, we'll reset this case to February 8th of 2023. Mr. Rojas, you can get your reset. Once you get your reset from your attorney, you'll be free to go. And tell him he have a blessed day, and you have a blessed day as well.
Thank you, Judge. You too.
Did you have dismissal?
Oh.
Yeah, Herta,
Okay,
do you have a dismissal for Herta?
thank you.
Yes. Court is in session and calls number 137977, case of style of state of Texas versus Willard Jerome Bannon II. Mr. Bannon, would you come forward? Your full name is Willard Jerome Bannon II?
Yes, sir.
How you doing, Mr. Bannon?
All right, you?
I'm doing fine. Thanks for asking, Mr. Bannon. You're here represented by your attorney, Attorney James Macon, who is appearing via Zoom. Attorney Macon, you can take your mic off of mute.
There we are, Your Honor.
Okay. How you doing, Mr. Macon?
I'm doing fine, Your Honor.
Okay, Mr. Macon, I have before me a petition for occupational driver's license that was filed by you on behalf of Mr. Bannon. And I reviewed the petition, and I see here that attached to the petition is an SR 22 and a driving record. Is that correct?
That's correct, Your Honor.
Which is required by statute. State, have you had an opportunity to review the petition?
I don't have the petition here in front of me right now, but I have had an opportunity to review it.
Okay, Mr. Macon, I just looking at the driving record, could you, let me show this to you. Okay. Okay, that's
The
it.
redactions are on there.
Yeah, but Mr. Macon, do you have a copy of that driving record?
I do, Your Honor.
I was looking, I see that he's charged in the criminal case with a DWI second. But I noticed that on the driving record, there's no indication that he had any DWIs. Or anything. I was just wondering, why was that? I was trying to figure out if we have to get a more updated driving record, or because they don't have anything on here.
Your Honor, I don't know why they don't have anything on there. He's charged with the DWI second.
Yeah.
I mean, that speaks for itself.
Yeah.
Out of state, possibly.
Oh, was it a hold on? Oh, I didn't think of, okay. Let me see, I'm looking at the information in cause number 332054, the criminal case. The enhancement paragraph alleges that the prior was in county court at law of Jefferson County, Texas.
Yes.
So,
So 10 years ago, Your Honor.
Why that's not, unless it's because of the 7-year cycle on the DL, that sometimes they'll purge the driver's license on a rotating 7 years.
oh,
Yeah, it was over 10 years ago. That's
okay, so it may have been purged. That's what you're saying?
Yes, Your Honor, because any type of movement violations such as that on a rotational 7-year basis, they tend to drop off. So if stuff's older case, like citations and stuff, older citations drop off.
Okay,
That could be the explanation there on that.
okay. Now, the other thing,
1 year.
Mr. Well, what did you say? You broke up.
He served 1 year probation, successfully completed it.
Okay. Okay, they said that it may not be on the driving record because I think after about 7 years, they may purge the record. And this has been like over 10 years. So that could be the reason why it's not on there. The other thing, the other question that I have regarding your petition is it doesn't state why his license was suspended.
Your Honor, in the very first paragraph, it was on June 21st, 22 for for 4-month suspension by TBS, according to the ALR.
It was a refusal.
Oh, is a refusal?
Yeah.
Okay, I mean, I didn't get that from the petition.
I should have been more specific, Your Honor.
Okay, so, are you doing a trial amendment?
I'm doing a trial amendment, Your Honor.
Okay, now State, do you have any, you see anything else that's, oh, if it was a refusal, what's that requirement?
The petition does request that or specify interlock on the vehicle, and that would be the only thing the state.
Right.
Right.
Right,
State that in the petition. So, you know, in circumstances and because of the defendant having to work and such, the SR 22 is supplied. The state is not opposed to granting the occupation.
Mr. Macon, did you hear that? The state is requesting that, because it's well, he should have an interlock anyway on a DWI second.
He already has it, Your Honor.
Okay, so that'll be a condition of the occupation of driver's license as well. The other thing is that, let's see. I think pursuant to Texas Transportation Code Section 521.2465. Let's see, it was a refusal. He must attend the following court-approved counseling and rehabilitation services and return proof to the court upon completion. One, he could do 8 hours of private counseling and rehabilitation service within 60 days, or he can do 8 hours of AA/NA meetings within 60 days. Okay?
Head of
And-
the arrest, Your Honor.
I didn't hear you. You kind of broke.
Does he need to do all that within 60 days of the arrest? Or is
No,
that
60 days, 60 days of him being given a occupational driver's license.
Oh, no problem at all, Your Honor.
Okay. Now, in reference to his driving restriction, I think that he's an operator at Motiva in Port Arthur. He works 12-hour shifts on a rotating schedule. The petition asks that he be allowed to drive no more than 12 hours in the 24-hour time period, Sunday through Saturday, 7 days a week. And in connection with his employment, petitioner will show an essential need exists that he be able to use a motor vehicle in the performance of his duties. Petitioner will also show an essential need exists that he be able to use a motor vehicle in performance of essential household duties and to handle all legal matters. Petitioner further requests the court enter an order allowing travel within the following counties: Jefferson, Hardin, Chambers, Harris, and Orange. Is that correct?
That's correct, Your Honor.
I think, if I'm not mistaken, by statute, in reference to him being allowed to drive his work vehicle, I think he has to give notice to his employer. Let's see, hold on a minute.
Yes, Your Honor, and notice the employer, and they issue a letter saying it's okay for him to drive their work vehicle.
Right.
I don't have work.
Okay.
Oh, so you don't have a work vehicle?
No, sir, I drive my truck.
Okay,
So,
okay.
working at a fixed location.
Yes, sir.
Okay. So, the court finds that Mr. Willard Jerome Bannon meet the eligibility requirements for the appointment for the occupation of driver's license. The court will draft an order to that effect. Mr. Baker, do you have anything else that you need to put on the record?
No, Your Honor, that'll be fine. As soon as I get it, I'll see that Mr. Brandon complies with the order regarding the counseling and attending 8 hours of AA and all that.
Okay, so. The court finds that it has jurisdiction and venue over this case. Because the offense was which petitioner's license was suspended happened in Jefferson County. The court finds that the petitioner has provided a certified abstract of the petitioner's driver's license record and an SR 22 responsibility insurance certificate. And the court finds that the defendant's driver's license was suspended because of a breath test refusal. The court also finds that the petitioner's driver's license is not denied, suspended, or revoked because of a physical or mental disability or non-payment of child support. The court further finds the defendant has not been issued more than one occupational driver's. Now, he hadn't been issued more than one occupational driver's license in the past 10 years. Is that correct?
That's correct, Your Honor.
And the court finds that the defendant's driver's license suspension began on June 21st of 2022 with a suspension for 24 months. And this is the court also finds in orders that the petitioner's occupational driver's license is granted subject to the following restrictions: to follow all restrictions listed below. The court finds that the Department of Public Safety to issue an occupational driver's license to petitioner subject to the following restrictions. The court further orders that the Texas Department of Public Safety to administer any and all tests required for the issuance of said occupational license. And if petitioner pass all required tests, issues an occupational driver's license subject to the following restrictions. Petitioners must not drive a commercial vehicle with this license. Petitioner must maintain a full force and effect of SR 22 automobile liability insurance policy for the entire period of the occupational driver's license. While the occupational driver's license is in effect, petitioner must have in his possession a certified copy of the court order while driving and must allow a peace officer to examine the order when requested. Number 4, the court also orders the restriction below: any vehicle owned or operated by the petitioner must be equipped with a working ignition interlock device in accordance with the Texas Transportation Code Section 521.2465. Petitioner must not refuse any lawful request by law enforcement, for example, a petitioner's breath or blood if stopped for driving while intoxicated. According to the Texas Department of Texas Transportation Code Section 521.245, petitioners must attend counseling and rehabilitation services. Petitioners may attend one of the following court-approved counseling and rehabilitation services and return proof to the court upon completion. Number 1, 8 hours of private counseling and rehabilitation services within 60 days, or 2, 8 hours of AA/NA meetings within 60 days. And the petitioner must only drive and operate at the Motivo Port Arthur. Petitioner works 12 hours a shift and rotating schedule. The petitioner will drive no more than 12 hours in a 24-hour time period, Sunday through Saturday, 7 days a week. in connection with his employment. Petition will show an essential need exists that he be able to use his motor vehicle in the performance of his duties. Petitioner, well, get to and from work. Petition will also show essential need exists that he be able to use a motor vehicle to perform essential household duties and to handle all legal matters. And petition is further is ordered. The court will also allow the petitioner to travel in the following counties: Jefferson, Harding, Chambers, Harris, and Orange County. And this is the order of the court. This order will take effect on the date that the court signed this order. Okay. State, you have anything else?
No,
Petitioner, on behalf of the petitioner, Mr. Macon, do you have anything else?
Nothing further, Your Honor.
Okay, the court will draft up an order and with these findings and orders as stated on the record. Okay, at this time, this hearing is concluded. Mr. Bannon, you're free to go. Stay in contact with your attorney. He should be getting a copy of the order, and you have a blessed day. Okay,
Thank you, Your Honor.
you're welcome. Mr. Macon, we have a plea that we have to do, then we'll get back to your next case.
That'll be fine, Your Honor.
John Self. Oh, the next one, yeah, thank you.
Your Honor, this is Mr. John Self.
Okay. Mr. Self, your full name is John G. Self?
Yes, sir.
Mr. Self, would you please raise your right hand? Mr. Self, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
I did.
Mr. Self, you may put your hand down. How are you doing, Mr. Self?
Good.
That's good. Mr. Self, I have before me, well, Mr. Self, you're here represented by your attorney Willard Hall. Attorney Hall, do you waive a record in Mr. Self's case?
Yes, sir.
Mr. Self, I have before me a document that is titled information. This document was filed by the Jefferson County District Attorney's Office. This document alleges that on or about January 8th of 2022, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed to Class B misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Self, do you understand what you've been charged with? And to this charge, Mr. Self, how do you plead guilty? Not guilty, no contest.
Guilty.
Now, you're pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? Okay, Mr. Self, I have before me a document that is titled misdemeanor plea admonishment. Do you recognize this document?
Sir.
On page 2 of this same document, Mr. Self, there is a box that's checked. And next to that box, there are a set of initials, JGS, on a line. Did you place your initials on this document, on this line?
Yes, sir.
On page 3 of the same document, there's a signature above a line that is titled defendant, and is this your signature?
Yes, sir.
On the next document that's titled trial court certification, the defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature above the line that's titled defendant?
It is.
At the top of this document, there are 2 boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
I do.
The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that? I also have before me a document that is titled discovery certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
It is.
Mr. Self, before you sign and initial these documents that I've just showed you, did your attorney, Mr. Hall, go over these documents with you?
He did.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Mr. Self, are you a citizen of the United States?
I am.
State, I have before me State's Exhibit number 1. State, you like to offer States 1?
Yes, Your Honor, state office station one.
Any objections?
No objection.
No objection. State's Exhibit number 1 will be admitted, Mr. Mr. Hall, you advised and counseled Mr. Self. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Self, your attorney, Mr. Hall, has advised and counseled you. Are you satisfied with his representation?
I am.
Has he provided full, effective, and competent legal representation?
Yes.
Mr. Self, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
Your Honor, in exchange for defendant's plea of guilty in this case, the state is recommending confinement in the Jefferson County Jail for a period of 90 days, Your Honor. We're asking that the court suspend imposing that sentence at this time and instead place the defendant on community supervision for a period of 1 year, required to pay a $500 fine and to complete 60 hours of community service. Your Honor, also we're asking that the standard DWI terms of probation or conditions of probation be imposed, Your Honor, to include an interlocutor by court.
Mr. Self, state is offering that you serve 90 days in Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail on this case because you will be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $472, which comes to a total of fine and court costs of $972. You will also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You'll be required to pay Jefferson County DWI education class an initial evaluation fee of $125. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is the total amount that you will be required to pay each month while you're on probation, is $165 a month. Will you be able to pay the $165 each month?
Yes, sir.
You will also be required to perform 60 hours of community service. You will attend and complete a DWI education class and have a drug and alcohol assessment. You will also be required to install the DWI interlock device on any vehicle that you own or operate, and you will also be required to adhere to the other standard terms and conditions of this probation. Mr. Self, do you understand the state's offer?
I do.
Do you think that the state's offer in your case is fair and just?
I do.
And do you accept the state's offer?
I do.
Mr. Self, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Self, you're going to stand on the X next to your attorney, follow the directions of our clerk. Once you finish following her directions, you'll be free to go and you have a blessed day. And Mr. Hall, you'll be free to go as well and you have a blessed day.
Thank you, Your Honor. Now, he lives in Louisiana. Will he be allowed to?
He has to talk to the probation officer so that they can transfer it.
Thank you.
If your right hand in the blue square.
Next case is cause number 331526. Case is style of State of Texas versus Dwayne Edward Carlisle. Mr. Carlisle is present in court. Mr. Carlisle, would you please come forward? Your full name is James Edward Carlisle?
Dwayne and Carl.
Excuse me, Dwayne Edward Carlisle.
Yes, sir.
How you doing, Mr. Carlisle?
I'm doing good. Thank you for asking.
That's good. Mr. Carlisle, you're represented in your case by your attorney, James Macon, who is appearing via Zoom. And the state is represented by attorney Lamar Johnson. Mr. Macon, I have before me a motion to remove GPS monitoring device that was filed by you on behalf of Mr. Carlisle. Is that correct, Mr. Macon?
That's correct, Your Honor.
And Mr. Macon, you'd like to go forward on your motion?
Yes, Your Honor.
Okay, you may go forward.
Your Honor, we would call Mr. Carlisle as witness.
Okay, Mr. Carlisle, would you please raise your right hand? Mr. Carlisle, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Carlisle, you may put your hand down. Mr. Macon?
Mr. Carlisle, state what you do for a living.
I'm a personal trainer and I just opened a gym in Port Arthur. So kind of what I'm doing for a living now. I train people. I do a lot of running with my clients because I'm not one that, hey, do this, do that. You know, I'm hands-on with them. So if these guys are running, these ladies are running, I'm running with them. The monitor's very, very cumbersome. My ankle's pretty bruised up. I mean, I've done everything I can to try to pad it. And it's very cumbersome. It's very painful, you know.
Okay, so it's interfering with you performing your duties at the
Sure.
gym.
Yes, sir.
Okay, how long have you been a resident of Jefferson County, Texas?
My entire life, sir.
Okay, have you made all court appearances as required?
Yes, sir. Don't miss no court dates.
Okay.
Address stayed the same. We're still the same. I've been in the same address for years, you know, so I'm not going anywhere. I want this.
Your Honor, we would pass the witness.
Okay, Mr. John,
Sure. Mr. Carlisle, are you alleged to have, in connection with this case that you're here for right now, this deadly conduct case, were you alleged to have, I guess, gotten mad at somebody who drove past you in a boat at a fast rate of speed?
Yeah, that's what I was alleged.
Okay, and is it alleged that you argued with, I guess, the person who drove by you in the boat?
Correct.
And during the argument, is it alleged that you?
Yeah, they alleged.
I'm going to object. We're going into matters not of this hearing that deal with the guilt or innocence of my client. You know, I would say that those are matters for another time. We're here on the removal of the GPS monitor only.
Your Honor, I would just say that I'm only asking about the allegation, not about the truth or the veracity of the allegations, but just the
okay,
allegation.
well, but I think he has a right against self-incrimination.
Sure.
But now what the court will do, the court will take judicial notice of the filings, the paperwork that's in there, which is a probable cause affidavit, et cetera. Okay.
Yes, Your Honor. All the allegations are coming straight
Okay.
to the PC. And I would
So
also,
I'm gonna sustain your objection, Mr. Macon.
Thank you, Your Honor.
Mr. Carlisle, have you been arrested in multiple counties in previously?
No, sir. I haven't been arrested. I've been in Jefferson County in 10, 15 years.
So you weren't arrested in Amarillo in 1996?
I was in prison in 1996.
So you weren't
No,
arrested?
no. Amarillo? No, sir. I was not arrested in Amarillo in 96.
Okay.
That's got to be wrong. 96, I was 18, still here in Jefferson County. I've never been a resident of Amarillo.
Not that you were a resident, have you been arrested in?
No, sir. Never been to Amarillo.
Okay.
lifelong resident of Jefferson County.
Are you a registered sex offender?
Yes, sir, I am.
So you never been arrested in Chambers County, anywhere in Chambers County?
Maybe Galveston, maybe 98, somewhere around there. Yes, sir.
So you have been arrested in multiple counties in
Yeah.
Texas? Okay.
I've been arrested outside of Jefferson County in over 20 years.
And were you placed on felony probation for 3 years?
Yes, sir.
And
Completed it. Completed it.
and during the probation, did you,
No problems whatsoever.
and you
I actually was released from probation early because of good behavior and taking care of everything.
and I guess one of the terms of your probation was that you had to periodically check in with your probation
Probation,
officer.
yes, sir.
Okay. Did you have a monitor in that?
No, sir, never
At
had
any
one.
time?
No, sir.
Did you think it was important to check in, like the condition of your probation?
Yes, sir. I always take care about every condition that's ever been rendered upon me.
In your opinion, why did you think it was important to have to check in periodically while you're on probation? Or what do you think is the point of that, of checking in during probation?
Only thing I would guess is just to make sure where I'm at, where I'm at.
Because do you think it's important that we know where you're at society, the county knows where you are?
I don't. I mean, I'm not a troublemaker, sir. I own a business. I own 2 businesses. I'm an upstanding citizen, sir.
But you received probation because of a criminal.
Because of yes, sir. Because of a criminal offense. But there's no more criminal offenses, sir. I mean, all my stuff that you're looking at is juvenile stuff. This is young, adolescent things. I'm a grown man now, sir. I was going through some things a while back where I lost my mother, and I went through a divorce. So I had a really hard stage in my life around 2009, 2010. I rebounded. I've got myself together. I'm on a straight and narrow path. Because me and someone had an argument or disagreement on the water and somebody's accusing me of something, I think this is a bit excessive. This is misdemeanor. I haven't done anything. I've got witnesses that stated that I didn't do anything, but yet I'm still standing here.
Carlisle, don't go into the facts of the case.
You're right. You're right. I'm sorry.
But do you agree that you've been arrested at least 15 times?
Yeah, if you count from when I was a child, yes, sir.
Okay. Pastor Williams.
Ms. Macon?
Mr. Carlisle, how long ago were all those arrests?
Over 20 years ago, Mr. Macon. I've got this misdemeanor that I was on probation for that I completed, and now this, since I've been home in 2008.
Okay. We have nothing further.
State, you have anything else?
How long were you, did you actually do pen time on the felony case that you called in 2016?
No, sir.
But that was, you would say that 2016 isn't 20 years ago.
That's what I just said, other than the misdemeanor charge I called. All my, yeah. No, it was a misdemeanor that was enhanced to a felony.
Okay.
Misdemeanor enhanced to a felony. It was evading detention enhanced to a felony. Because I had one when I was 16.
Right, so it was enhanced to a felony because you had previously been convicted of the same thing.
As a child. As a child.
But you were previously convicted of it.
But yes, sir, as a child, not as an adult.
And and as an adult, do you think that taking accountability and responsibility?
Absolutely. I take all of the responsibility.
76.
Yeah,
You're born in 76.
yes, sir.
Okay, so in 96, you were 20.
Okay. Yes, sir.
Okay.
Well, I'm not able to remember, sir.
Anything else?
Nothing further.
Mr. Macon, you have anything else?
Nothing further, Your Honor.
Okay, the court is gonna deny this motion. Okay. All right.
Supposed to do much, okay, how am I supposed to make a living? This is.
Mr.
This-
Mr. Carlisle, you have an attorney. You can talk to your attorney, your right against self-incrimination. Anything you say can and will be used against you in a court of law. And this is the ruling of the court. Okay,
You don't even have the evidence that I'm doing anything. I know.
Mr. Carlisle, give my office a call and make an appointment.
Sir.
okay. Mr. Carlisle, you're free to go and you have a blessed day. That door is locked. You got to go through the other door.
It's all because I'm convicted and I was registered sex offender. Why y'all are doing this to me, man? All of you, sir. I ain't done nothing.